Hearing in the appeal Hancock and another against Commissioners for Her Majesty's Revenue and Customs.
Mr. Sherry.
My Lord, my Lords and my Lady, please your Lordship, I represent Anthony and Tracy Hancock in this appeal. With me is Miss Jimena Montes Monzano and my learned friend Michael Gibbon QC and Miss Elizabeth Wilson represent the revenue. My Lord, as a matter of housekeeping, I think clearly you've got the timetable. There's been some additional materials, so you should have a thin binder with additional materials in it. A ring binder, perhaps. I think it's just beside you there, black. That's the one.
Supplemental bundle.
Supplemental, I beg your pardon, my Lord. And overnight there was an email about a couple of minor typographical errors in the...
Yes, reference to section 49 instead of section 41.
One, indeed, my Lord. On the basis that you've already read the statement of agreed facts and issues, the written cases and the decisions below, I don't anticipate using up the whole of my allotted time.
No, it struck us as being quite a short point once you've worked your way through the legislation.
Indeed, my Lord. And on the premise that you've obviously discussed that, I will take you on a whistle-stop tour through the legislation to make a couple of points and then concentrate on the main issues, and that again may speed me up. We will look in detail at 132 and 116, yes. But just to put it in context, I'll look at 115 and we'll look at the provisions around 132.
And can I just say, Mr. Cherry, you're quite soft-spoken. I'm just mentioning that. And in particular, if your clients are in court and would like to come further forward, then of course they're very welcome to.
This is my team.
Ah, right.
Thank you. I'll bear that in mind. I hope I'm audible to your Lordship.
You're more audible now than you were a minute ago.
Thank you, my Lord. So, if I may start with a brief reference to the facts, and if I may take you to the core bundle, core volume at MS 40. We have the statement of agreed facts and issues, and that records the whole process that the taxpayers went through, and the event that we're concentrating on for present purposes is in paragraph 10, the event on the 7th of May 2003, where each of the taxpayers, Mr. Hancock, Anthony Hancock and Tracy Hancock, started off with 2 loan notes and ended up with a new secured discounted loan note, an SDL, as is referred to there. And then in paragraph 11, the secured discounted loan notes were redeemed, and so we're concerned with the question of the tax that arises on the redemption. And that tax will arise because, if it does arise, of the operation of 116, because it's common ground that the SDL, the secured discounted loan notes, were qualifying corporate bonds, and so looking at them in isolation, they didn't give rise to a chargeable gain on their disposal by virtue of section 115. Whilst we're on factual matters and just thinking about that transaction.
Can I just ask?
Yes, of course.
Does it follow that there was no separately identifiable consideration for the loan notes which were not QCBs?
On the exchange? No, my lord, and I'll take you very briefly to the agreement which covered the exchange in a minute. You will have seen in our written case that we made a brief reference to the first-tier tribunal, which had considered that there were commercial matters also dealt with in the agreement, and I just want to take you through that so that if you go to MS 148, which is in the first-tier tribunal decision at page 57 of the appendix. And just picking up at paragraph 20, you'll see that according to Mr. Hancock, the more substantial restructuring exercise that was then required with Lionheart's cooperation, so this is before the paragraph 10 exchange with which we were concerned, the 7th Amendment exchange, with Lionheart's cooperation turned out to be an altogether more difficult and expensive process than the first restructuring. There was no guarantee that Lionheart would agree to this more substantial restructuring of the B loan notes 2004 and the revised B loan notes 2004. And as it turned out, the process required a number of related commercial issues to be addressed. One of the issues related to the redemption of the A loan notes. Contrary to Mr. Hancock's original understanding, he became aware around December 2002 that he might be able to, under the terms of the A loan notes 2007, redeem those notes earlier than in 2007. Having been advised by Mr. Edwards, that's his accountant, on the 18th of December 2002, that the earliest available date for redemption of those notes was 31 March 2003, and that 30 days business notice was required, Mr. Hancock gave notice of redemption on the 12th of February 2003. As part of the commercial negotiation for the restructuring, Mr. Hancock agreed on the 31st of March 2003 to withdraw that notice. So that happened, and then in paragraph 22, another issue related to Jersey income tax, which had been wrongly deducted, and in the last sentence of paragraph 22, the first-tier tribunal records that issue was resolved under the terms of the agreement dated 7th of May, which provided for the issue by Lionheart of the secured discounted loan notes in exchange for the cancellation of the B loan notes and the revised B loan notes. Now, if we turn to that agreement now, my lord, it's not very long, we'll find it at MS 345. It starts at 344. And you will see that the parties are Blue Beckers Holding Limited, which was the original purchaser and issuer of all the loan notes, Anthony Robert Hancock and Tracy Lee Hancock, and Zaban nominees, because a charge had been granted over the loan notes, the B loan notes held by them both in favour of Zaban, which was a company which acted as part of the Barclays banking group. So the charge secured borrowing from Barclays. And if you turn the page to the operative part of the agreement, it's brief enough. Clause 2, 2.1 in the consideration of the issue by the company to the second loan note holder of the nominal amount of secured discounted loan note 2004, each of the first loan note holders and the second loan note holder hereby agree to the cancellation of each of the revised...
Which clause are you reading from? 221.
2.1, my lord.
Sorry.
So that's the operative part in relation to the exchange. And of course, at this stage, Zaban held the previously issued loan notes as security and was going to hold the new loan note in substitution. And then 2.2.1 deals with the Jersey taxation. And it's provided that it shall, the amounts incorrectly withheld from previous payments set out in column 3 of the schedule shall be repaid to the first loan note holder. And that schedule, my lord, if you want to look at it, is a couple of pages further on. You can find it at MS 349. And you can see in column 3 that the amounts involved are not inconsiderable. The point being that there were a couple of other commercially important matters which were dealt with in the negotiation and in the agreement itself. One, the giving up of the notice on the 31st of March as a sweetener to Bluebeckers. The other, Bluebeckers agreeing to pay that interest as well. And so this is, the other thing to notice is that this is not an agreement where there is any division up or separation of what's received as between the elements of the consideration given in the form of the old loan notes. And that's relevant in the context of 116 and what is the nature of the, to use a neutral term, the event that we're looking at. I rather think the draftsman of 116 used the term transaction, trying to be neutral, but that's acquired a contested meaning in these proceedings.
But insofar, the point being that insofar as there are two distinct categories of security being converted, there's no, the agreement doesn't provide for separate consideration in respect of each category.
Indeed, my lord. Yeah. And just before, not quite sure why it's in this order, but just in front of the agreement, you will find the actual loan notes that were issued pursuant to it. So if you turn to MS 330, you see there's a secured loan note in the amount of 4615180, secured discounted loan note 2004, so this is a new loan note, and that's the amount that Mr. Hancock, of the nominal amount of Mr. Hancock's previous loan notes, and if you turn to page MS 337, you find the other loan note issued for 5109471, which is the amount of Mrs. Hancock's, Tracy Hancock's notes before the exchange, and this is the new one. A minor point, and perhaps my learned friend will deal with it, but it's convenient to look at it at this stage. At MS page 83, this is in the respondent's case. It said there is nothing in the facts that acts as a bar to the Court of Appeal's construction. Indeed, in agreeing to the statement of agreed facts and issues below, it is notable that the appellants were content to describe this case, both linguistically and conceptually, as involving two separate conversions. And the footnote there takes us to MS 143 in the first tier tribunal decision. Beg your pardon, it takes us to page 52, which is indeed 143. And you will see, starting on 142, the first tier tribunal sets out the statement of agreed facts that was before the tribunal. And in relation to the event we are concerned with, you find on page 143 at subpara 9, para 9 of the Statement of Agreed Facts and Issues, the reference to our event on the 7th of May, the B loan notes issued in August 2000 and the revised B loan notes issued on 22nd of March 2001, beneficially owned by Mr. and Mrs. Hancock, were exchanged for two secured discounted loan notes, one with a nominal value of 4615180 in the case of Mr. Hancock, and one with a nominal value of 5109471 in the case of Mrs. Hancock. And we've seen those just a moment ago. After the exchange, the secured discounted loan notes 2004 were qualifying corporate bonds within section 117. So I don't myself properly understand what the Crown are saying at paragraph 48 of their case. There are two new loan notes, but it's one each for each of the taxpayers. My learned friend points out that the cross-reference is to page 6A on 143 at the bottom of the page in terms of the issues. And this is what the Crown was discussing. So the issue was whether or not there was one conversion or two. And so that's at the foot of the page, whether or not the conversion of the Bean Loan Notes 2004 issued on 24th of August 2000 and the conversion of the revised Bean Loan Notes 2004 issued on 22nd of March 2001 into the secured discounted loan notes on 2004 on the 7th of May 2003 are to be treated as a single conversion or two distinct conversions for the purposes of 116. My Lord, I think agreeing that that's the issue is simply takes us no further forward. We're not agreeing that there are two separate conversions. We're saying that there aren't. So, my Lord, if I may take you to the legislation, excuse me. So we're in Authorities Volume 1. I don't think I need to take you to section 2, which is the general charging provision, or indeed section 21, which deals with assets and gains and disposals. 115, just to note that that's at MS 480. That's the provision which grants, which provides that a gain accruing on the disposal of gilt-edged securities or qualifying corporate bonds shall not be a chargeable gain. And then we find 116 at page 481. And at this stage, I'm just going to take you through it very quickly. I will come back to it, but I want to look at the reorganisation and reconstruction provisions first before I come back. But to note at this stage, as you will have already gathered, it's subsection 1b which gives rise to the difficulty. And the point I would like to make at this point is that you have to come within 1161b to be taken out of sections 123 to 130. So the operation of the section is you either fall within the three cumulative, you satisfy the three cumulative conditions in subsection 1, and if that's right, then subsection 5 provides that you come out of sections 127 to 130. It's a very brief provision. And if that happens, the essentials then take us to paragraphs, subsections 9 and 10. 9 provides, in any case where the old asset consists of qualifying corporate bond, of a qualifying corporate bond, then so far as it relates to the old asset and the new asset, the relevant transaction shall be treated for the purposes of this Act as a disposal of the old asset and an acquisition of the new asset. So that would trigger, for example, a gain in a QCB which had arisen at an earlier stage and been deferred on an earlier transaction. And then we find in subsection 10 that subject to the exception in subsection 9, the general rule is that so far as it relates to the old and new asset, the relevant transaction, that's the transaction within subsection 1, shall be treated for the purposes of this Act as not involving any disposal of the old asset, but subparagraph A, there shall be calculated the chargeable gain or allowable loss that would have accrued. B, subject to 12 to 14 below, which aren't relevant for present purposes, the whole or a corresponding part of the chargeable gain or loss mentioned shall be deemed to accrue on a subsequent disposal of the whole or a part of the new asset. And C, on that subsequent disposal, section 115, which relieves, it takes the disposal out of chargeable gains, only has effect in relation to the gain which actually accrues on that disposal, and not in relation to any gain or loss which would have deemed to accrue by virtue of B. Now, at this point, I would simply draw your attention to the contrast in language between subsection 1b, which deals with original shares which would consist of or include a qualifying corporate bond in lim A, and the new holding would not, or the original shares would not, and the new holding would consist of or include such a bond. So we've got those words, that phrase, consist of or include, in subsection 1. In subsection 9, the reference is to the case where the old asset consists of a qualifying corporate bond. And the other cases are dealt with under 10. And that suggests, to me at least, and that it's part of our submissions, that the words, the composite phrase consist of or include in 1B are deliberate. And the inclusion, forgive me, of include is not anomalous, but operative in the way in which the section is intended to apply. And we say the clue to that is in subsection 9, where include it does not appear.
And I wonder if it's relevant in that regard to note that in subsection 3 and subsection 4, the expression is constitute.
Rather than consist. I'm obliged, my lord. That there are, I think we agree, some difficulties with the drafting of this section. But the thrust of what I'm going to be saying to you today is that there are more difficulties than can be cured by the approach that was taken by the Court of Appeal.
Well, what does constitute mean in paragraph 3, subsection 3?
Well, interestingly, the First Tier Tribunal described that language as anomalous. And it clearly, if one reads the consist of or include a qualifying corporate bond in 1B and takes that as the starting point, then in 3, one would read constitute as referring to the holding which consists of or includes a qualifying corporate bond.
So, say you had 100 bonds, one of which is a qualifying corporate bond. Say you've got 99 that aren't. On your approach, that would fall within the expression consist of or include, because one of 100 is qualifying.
That's subject to a de minimis approach, yes, my lord.
Would that one qualifying bond, in terms of 3, constitute the original?
No, I would say that the holding constitutes the new asset.
Right, the holding of the 100 shares.
Of the 100 bonds. So the starting point here, and this is why I want to take you to the reorganisation provisions, but the starting point is that you're not looking at this provision unless you would otherwise be within the reorganisation and reconstruction provisions, where you have the concept of mixed holdings or holdings made up of more than one asset, which are called original assets and new holdings. And when you come to read subsection 3 to make sense of this, you see that what the section is doing is adopting a similar approach. The draftsman has borrowed that approach and refers to old assets. What's it to apply to? It's the qualifying corporate bond element in 1B, which consists of and includes a qualifying corporate bond if it's on the input side, or if it's on the output side, that ends up being the new asset.
Still not clear how you read 3. I mean,
Yes.
Are you saying that where the qualifying corporate bond would constitute the original shares, you mean would constitute or be part of the original shares?
That would be a way of reading it.
Well,
Make sense of it.
I'm not trying to do that. I'm trying to find out how you read it.
I would read it in that way, yes.
Then what is the old asset? Is it all the shares or just the...
It's all of the holding that's on the input side, so that when you come to sub 10,
Yeah, no, but let's look on 3. You're saying it's in where the qualifying corporate bond would constitute or be part of the original shares, it is in this section or it and the other shares are referred to in this section as the old asset. Is that what
that would be a reading which would make sense of it, my lord, and I would subscribe to that as a possible interpretation.
writing, isn't it?
It's not straightforward, I agree. I will come back to this, if I may, after we look at the reorganisation provisions. So if I may take you away to them at this point, and in particular, to 126, which you will find at MS 488. Behind tab 10. So, my lord, 126 sub 1, for the purposes of this section and sections 127 to 131, reorganisation means a reorganisation or reduction of a company's share capital, and in relation to the reorganisation, original shares means shares held before and concerned in the reorganisation, and new holding means in relation to any original shares, the shares in and debentures of the company which as a result of the reorganisation will represent the original shares, including such, if any, of the original shares as remain. And then subsection 2 deals with the meaning of reorganisation, and subsection 3 deals with redemptions that occur in this context. Nothing turns on them particularly. So the importance of 126 is the original shares and new holding definitions. And that this is the reorganisation and reconstruction scheme onto which section 116 is parasitic. So if we turn to 127, which is over behind the next divider at MS 490, we see the operative part, subject to section 128 to 130, a reorganisation shall not be treated as involving any disposal of the original shares or any acquisition of the new holding or any part of it, but the original shares taken as a single asset, that's clearly a reference back to 126 and the meaning of original shares, and the new holding taken as a single asset shall be treated as the same asset acquired as the original shares were acquired. So, my lord, sometimes been said that this provision involves two fictions, a no disposal fiction and a single asset fiction. The point of the single asset fiction being that there may, in a reorganisation, as we will see in any of the other provisions to which these provisions might apply, there may well be more than one asset involved on the input side and more than one asset involved on the output side, and that is fundamental to the thinking behind these provisions that it's designed to eliminate all the difficulties which might arise from trying to untangle what happens where you've got more than one asset involved, maybe on one side or maybe on both sides. By saying that it's a single asset throughout, you don't have a difficulty about attributing base cost subject to what we will see in a moment. So if you then turn the page to the next divider 8, page MS 492, you'll find section 128. And this deals with the case where in one of these transactions there might be consideration arising either payable to the holder of the original shares or paid by the holder of the original shares. And that would, a typical case where the holder of the original shares might be making a payment, would be a rights issue, where the original shares are still there, additional shares are acquired, and some money has been paid. And so what is provided for here is that in the ordinary case, that gives rise to a treatment of the proceeds which modifies the consideration given for the new holding. Then we have quite important provisions in the next divider 9, which is MS page 494, which is section 129, which deals with part disposals of the new holding. And it says, subject to 130 sub 2, which we'll look at in a minute, where for the purpose of computing the gain or loss accruing to a person from the acquisition and disposal of any part of the new holding, it's necessary to apportion the cost of acquisition of any of the original shares between what is disposed of and what is retained. The apportionment should be made by reference to the market value at the date of disposal. That's the ultimate disposal, not the date of the reorganization, with such adjustment of the market value of any part of the new holding as may be required to offset any liability attaching thereto, but forming part of the cost to be apportioned. Now that last phrase in parenthesis deals with the question of partly paid shares which haven't been fully paid up, and so would deal with the case where there's been a reorganization and then perhaps there hasn't been a call on a bonus issue yet, but the shares are sold subject to the purchaser assuming the liability on any future call. But subject to that, the rule here is simple, and the costs which accrued in respect to the original shares, whatever assets that consisted of, are allocated to the part disposed of by reference to the market values of the part disposed of and the part retained at the time of the disposal in question. And my lord, you may recall that for capital gains tax, section 46, the general rule involves an allocation of base cost when there's a part disposal between the consideration received and the market value of the part retained, which is not quite the same as this. And then very briefly, if we turn to page MS 496, behind the next divider, we see section 130. And this deals with composite new holdings where one or more of the elements in the new holding is quoted. So 130 sub 1, the last line had quoted market values on a recognised exchange in the United Kingdom or elsewhere, and B deals with unit holders and unit trusts where there is a quoted buy-in and price. And in those circumstances, what subsection 2 does is to cause the allocation to be done at the time that the quotation is first available. So it's by reference again to market values at that time. So supposing the new holding consists of, let us say, shares and QCB, possibly, and the shares are quoted shares, then you would do the allocation of all the costs of the old assets, whatever they were, by reference to the quoted price when those shares first had a quote.
It's not just that you have shares and debentures, it's more than one class of share, or more than one class of debenture.
Yeah, yes, indeed. The next section behind the next tab is in for completeness, but we don't need to look at it. It deals with indexation allowance, which is not an issue in this case, and I don't think has any bearing on the issues we are confronted with. So if we then turn to MS page 499 behind tab 12, we see section 132, which is the provision that deals with conversions. And you'll have seen this in the decisions below. Sections 127 to 131 shall apply with any necessary adaptations in relation to the conversion of securities as they apply in relation to a reorganisation. That is to say, a reorganisation or reduction of the company's share capital. And that takes one back to 126. This section has effect subject to 133 and 134. Again, we're not concerned with 133, and it's not in the bundle. 134 we'll look at in a minute. For these purposes, under subsection 3A, conversion of securities includes any of the following, and then whether affected by a transaction or occurring in consequence of the operation of the terms of any security or of any debenture which is not a security, that is to say, and those words in square brackets were added at the same time as subparagraphs little Roman 1A and 1B in 1997. And we say because this provision was on the statute book from 1992 and in substantially the same form since 1965, the addition of those words and those subsections can't change the way in which it should be construed. The categories include a conversion of securities into shares, the specified categories, a conversion at the option of the holder of securities converted as an alternative to redemption, and any exchange of securities effected in pursuance of any enactment, including an enactment passed after this Act, which provides for the compulsory acquisition of any shares of securities and the issue of securities or other securities instead. And then security is widely defined, and in the context of 3A, Roman 1A and B, subsections 4 and 5 further extend the definition of security by reference to contemporaneous amendments, 1997 amendments, which again are not of significance.
And insofar as Mr. and Mrs. Hancock's securities were not qualifying corporate bonds, we're within paragraph A, Roman 1A, aren't we? A conversion of a security which is not a qualifying corporate bond into security of the same company which is such a bond. Or have I got that wrong?
Indeed, my lord, yes. If one looks at if one separates the two elements and looks in isolation at the original non-qualifying corporate bond and says that that was converted into a qualifying corporate bond, it would fall within 1A. But it is perhaps worth bearing in mind that the mischief at which those 1997 amendments were aimed was the circumstance referred to in the words in square brackets in the opening of paragraph A, whether effected by a transaction or in consequence of the operation of the terms of any security. And that the mischief that little Roman 1A and 1B was aimed at, was the sort of scheme considered in Clink and Harding, where either by fluxion of time, a term ceased to have an effect, and so what had not been a QCB would become one, or there was an amendment to the terms of a single security. And the clue, we say, to what those amendments were aimed at is to be found in the use of the singular, a conversion of a security. We would say before those amendments were made, a conversion of a non-qualifying corporate bond into a corporate bond would be a conversion of securities in any event. This is not a definition. This is simply a provision which makes plain that the following things are included. And the ordinary meaning of a conversion of securities would apply to a conversion of any loan note into a different loan note.
Yeah. I'm sorry, can I just check? The QCBs which were issued in 2003 were issued by Bluebecker.
Yes.
We saw those. The original securities, original loan notes were they issued also by Bluebecker?
Indeed, my lord, it was the same company.
Right. I just asked that because I think I'd read somewhere they were issued by Lionheart.
Yes, it changed its name. So at the time of the original acquisition, the name of the company which the Hancock sold was Bluebecker's.
Yep.
And the company which acquired was Lionheart,
Yep.
which subsequently changed its name to Bluebecker's because it was the holding company formed to acquire the trading
Oh, I see.
company. So Bluebecker's was a chain of,
Right.
I hope I get this right, fast food restaurants.
Yeah. So both the original loan notes and the ones which were their replacements, effectively in 2003, were all issued by the same company.
Indeed, my lord.
Right, thank you.
So what are you saying about little 1A then, in terms of this appeal? You said
It doesn't really shed any light on the problem as to whether or not a transaction or an event of the sort we're concerned with falls within section 132 as a conversion without the extension of the meaning of conversion to be found in those paragraphs. And we say it does fall within that meaning because what section 132 and indeed all of these sets of provisions do is to look at a process and to apply where there is more than one asset involved as well as where there's only one asset involved in either side, to apply the two fictions to be found in section 127. So if one then turns to 134, we see a provision dealing with compensation stock. So that 132 is originally enacted at MS 499, had in subsection 3, paragraph A, little Roman 3, had a reference to securities, any exchange of securities effected in pursuance of any enactment, including an enactment which provides for the compulsory acquisition of any shares or securities and the issue of securities or other securities instead. So that's dealing with nationalizations and matters of that sort. And that was in section 132 in its original form. If we then bear in mind that gilt-edged securities gained their exemption in 1969, and the additional materials, supplementary materials bundle includes section 41 of the Finance Act 1969, which was the provision which brought in the exemption for gilts. I don't need to take you to it. So from 1969 at least, it was possible that you would have a transaction where taxable inputs would result in exempt outputs without there being a charge suspended or crystallized on the exchange. And that's mentioned in our written case. And that continued to be the case until 134 was enacted in 1976, or the predecessor to 134. And what 134 does is to take transactions of that sort back out of section 132, where the consideration given on the exchange is gilt-edged securities. And what that does is to, under subsection 2, provides that the exchange shall not constitute a conversion of securities within section 132 and shall not be treated as involving any disposal of shares by the person from whom they were compulsorily acquired. And just noting that subsection 6 here says shares includes securities, so we're dealing with all types of securities. And instead, paragraph A, there shall be calculated the gain or loss that would have accrued to him if he had then disposed of the shares for a consideration equal to the value of the shares as determined for the purposes of the exchange, and B, on a subsequent disposal of the whole of the part, there shall be deemed to accrue to him the whole or corresponding part of the gain, and section 115, as is, shall not have effect in relation to any gain. So that's the provision relating so far as it does to gilts and preventing charge on gilts.
That's where gilts will be fiscally homogeneous consideration. If there isn't anything else other than gilts which constitutes the compensation.
There, in the transaction that would be within this provision, in subsection 1, provides for the compulsory acquisition of any shares, which includes securities, and the issue of gilt-edged securities instead. So that's confined to gilts. So if one takes it literally at any rate. Taking it literally, if there were a mixed consideration, this provision wouldn't, on the output side, this wouldn't kick in, although that is maybe an argument for another day. So you will notice that although it's set out slightly differently, the operative part of sub 2 is in virtually identical terms to the operative parts of 116 sub 10. Although in sub 10, 116.10, the sub-paragraphs little Roman 1 and 2 in B are split into C. And you will see in subsection 4, no gain, no loss disposals are dealt with so that the gain that has been suspended doesn't crystallize at that point, but is nevertheless held in abeyance by the new holder. So, for example, in subsection 4, you'll see a reference to section 58 sub 1 that deals with transactions between spouses and civil partners and provides that no gain, no loss shall arise on such a transaction. Section 62.4 deals with a legatee taking post-death, and 171 is intra-group transactions, no gain, no loss. And those subsections 4 and 5 are mirrored in 116 in the subsections following subsection 10. So the difference, the draftsman of 116 sub 10 borrowed from 134, but had an exception for reasons which I'm not clear in those cases falling within 116 sub 9. Conscious of the time, I'll try and speed up a bit. If I may take you to 135, which is MS 503 behind tab 14. Here we find the provision dealing with the exchange of securities, and this applies in circumstances where a company B issues shares or debentures to persons in exchange for shares or debentures of another company, company A. And I think in both cases the use of or is in a conjunctive rather than a disjunctive sense. So you might have shares and debentures in company A, and company B issues possibly shares, possibly debentures, or possibly a combination in consideration of whatever you've got in company A. And we see in subsection 2 that there are 3 cases where this can apply, and case 1 where company B holds, or in consequence of the exchange will hold, more than 25% of the ordinary share capital of company A. So this could be a takeover, or it could be dealing with a minority interest in a company which company B either has a big stake in or a majority interest even. Case 2 is a general offer to the public, so that would be a market type offer or something of that nature. And case 3, like case 1, but as a result of or before B holds the greater part of the voting power in company A. So transactions which might fall within this provision could include ones with mixed inputs and mixed outputs, or various combinations thereof. The point being that if the approach adopted by the Court of Appeal to conversions is correct, namely that you have to apply, in the case of non-tax homogeneous mixed inputs, you have to apply the provision twice to each input separately, then the same would be true here.
Would that matter?
Well, it could well do. And when we come back to look at the various different types of combination of transaction which might fall within 1161B, it could have wide application. If it were to matter, the question as to whether or not it matters, my lord, I think what I would say is that the scheme appears to be, in terms of 127, the single asset fiction, that you keep all these things together. And the approach adopted by the Court of Appeal in relation to 132 has said, well, in this particular case in conversions, you have to separate them to make sense of 116. But it goes wider than that, is the point I'm making. It would be could be of quite wide application. Now, that might not matter if there were clear words indicating that that was to be the case. But one of our submissions is that the words we've got don't tell us whether or not it's just confined to securities or whether it covers the other provisions, and we don't know. And so if the essence of the Court of Appeal's decision is that a parliamentary slip is being cured, then there's a question mark of, well, how wide is the slip, what does it cover, and how is it being cured, and is that something that's capable of a judicial fix, or is it too difficult, involving too many aspects?
Does it matter that subsection 3 uses the words with necessary adaptations? I appreciate that applies only to sections 127 to 131.
It matters, and you will see that phrase in each of these provisions. So in 132 itself, it's in the first line. In 135, you find it in subsection 3. And in 136, in relation to reorganisations, which is at MS 506, you find it in subsection 2B. So there have to be necessary adaptations to the provisions of 127 to 131 because those provisions in 127 to 131 use particular language. They talk about shares and reorganisations. And in each case, whether it's conversions, exchanges, or reconstructions, necessary adaptations to make 127 to 131, 130 do anything at all require you to take out the word shares and put in, as the case may be, securities or shares and debentures, as the case may be, and to take out the word reorganisation and to put in conversion of securities, exchange of securities or shares and securities, and so on. So the point arises in respect of the three sets of parasitic provisions, 132, 135 and 136, they all apply the provisions of 127 through to 130 with necessary adaptations. We say those adaptations are the ones which are necessary to give effect to 127 through to 130 for the purposes of each of the subsequent provisions. And what those necessary adaptations were and had to be must have been known before the advent of qualifying corporate bonds. So before 1984, it must have been possible to say what the necessary adaptations were, and there's nothing in the language of the amendments made in 1984, which now, or in 1997 for that matter, which forces one to alter the meaning of the necessary adaptations as it was before.
Surely with necessary adaptations, it has to be given a contemporary meaning. It's a dynamic phrase.
Well, my lady, yes, but if one's saying that they're necessary for the purposes of applying 132, not for the purposes of disapplying it under 116.
I'm sorry, I haven't quite understood the distinction.
Well, the essence of the Court of Appeal's decision is that the occasion where you have a conversion of securities, where you have a taxable and non-taxable on the input side, requires that you apply 127 to 130 as though there were two separate conversions. And it said that that's necessary in order to bring, or to be consistent with the operation of 116, or the purpose behind the operation of 116. But what 116 does is to disapply 132. So what the effect of the Court of Appeal's decision is to make an adaptation, if that's the right word, and we submit it's not, to make an adaptation which alters the way in which 127 to 130 apply for the purposes of 132 so that it can be disapplied. And we say it's just not a natural meaning of the word necessary adaptations. It goes too far. And moreover, we say there's nothing in the language of 132 which either before or after requires 127 to 130 to operate in a different way by reference to the tax status of the inputs. And if one looks at 132 subsection 4 and 5, which were inserted in 1997 when the two further categories were added to the list of inclusions in sub 3, it would have been easy enough for the need for different treatment of inputs of non-homogeneous, non-tax status homogeneous inputs to be made plain. It's not there.
What do you say are the necessary adaptations?
I did set those out in our written case, my lord. At least I hope I did. But
Paragraph 25.
yeah, paragraph 26 on MS page 57. And that is by reference to 127, how it would be adapted. So to get it to work at all, what's necessary, the reorganisation becomes conversion, the reference to shares becomes securities, and so on.
You say it's not necessary for the purpose of section 116, because the whole point is that you look under section 116 as whether section 127 and so on would apply apart from section 1.
Yes. And so here, what is it suggested goes into 127. What words would be read in to 127 to make it do what the Court of Appeal say it should do, which is to treat the non-homogeneous conversions as two separate conversions. And we don't know.
Or alternatively, whether the conversion limited to the QCB element is the conversion for the purposes of section 132, which is therefore within 116.
Indeed, my lady.
Another way of putting it.
It's another way of putting it. I would add whether or not that conversion on its own falls within 116. It's perhaps worth noting in passing that section 137, which is not in the authorities bundle, we can pass it up if your lordships and your lady, if you require. But section 137 is an anti-avoidance rule which applies in circumstances where the sole and main benefit of the transaction is tax avoidance, but it only applies so as to disapply either section 135 or 136. Parliament has chosen to put in an anti-avoidance provision in respect to share exchanges and in respect of reconstructions, but not in respect of reorganisation simpliciter, nor in respect of conversions. It's at this point, my lord, if I can take you back to section 116. And if we look at 116(1)(b), and just break that down a bit as the Court of Appeal did, on its face it applies where the original shares would consist of or include a QCB and the new holding would not. That is what I think Lord Justice Floyd referred to as lim A. Or the original shares would not, and the new holding would consist of or include such a bond. Now we say that there are logically four possibilities included in that use of language. So that in lim A, the original shares could consist of a qualifying corporate bond and the new holding would not, or the original shares would include a qualifying corporate bond and the new holding would not. That's the two cases within Lim A. And then likewise in Lim B, the original shares don't include a qualifying corporate bond, but the new holding would, case 3, consist of such a bond, and then case 4, the new holding would include such a bond. And we've already seen the language in sub 9, which applies a different taxing provision at a different point in time to one of those 4 cases where the original shares consist of a qualifying corporate bond, but one only. So we can see that the draftsman is not using these words lightly, because he's using them to distinguish between a tax charge arising immediately under sub 9 and a deferred tax charge which may or may not arise at some future date under sub 10. And there are some other possibilities which don't fall within certainly the literal meaning of the words in 1161B. So it is possible that the original holding can consist of a QCB alone, and the new holding can consist of a QCB alone. That is not within 1161B, nor is it meant to be. Because if you have a QCB, it might have what's often referred to as a stapled on gain, which has arisen under this provision at an earlier stage. And if it's swapped for another QCB, and the section 132 applies, then that staple, there's no disposal, so that staple gain is still attached to the new asset, which is treated as the same asset as the old one under the single asset fiction. So the omission of QCB simpliciter into QCB simpliciter appears to be quite deliberate, and that makes perfect sense. The next possibility is that you might have on the input side a QCB and a non-QCB, and on the output side a QCB.
I don't want to take you out of your order, but I wonder if I might just put something to you. As you don't have an enormous amount of time, and we need to get to the guts of the point at some stage. I mean, you're focusing on inputs and outputs, and obviously you have to identify what the relevant transaction is before you can identify what the input and the output may be. And the argument against you, as I understand it, is that that section 1162 tells us that references to a transaction include references to any conversion of securities within the meaning of section 132. And when you look at 132, which is on MS 499, subsection 3A contains a definition of a non-exhaustive definition of conversion of securities, which addresses qualifying corporate bonds specifically in heads Roman 1A and 1B, and is framed in the singular that The conversion of securities, I mean, when it comes to securities in general are dealt with in the plural, a conversion of securities of a company into shares, for example, in one. But when it comes to QCBs, the focus is on a conversion of a security which is either not a qualifying corporate bond under 1A or a conversion of a qualifying corporate bond under 1B. And it can be said against you that here that the conversion of each of the 2,000 loan notes held by Mr. Hancock and by Mrs. Hancock constituted a conversion of a security which is not a qualifying corporate bond. And that is said for both linguistically and in terms of what one would expect in terms of the ordinary consequence of chargeable gains. That's said to be the relevant conversion of securities for the purposes of 116 subsection 2, and therefore that is the relevant transaction. So that the input is necessarily one which can't include a QCB so far as the 2000 bonds are concerned, because we're talking about loan notes which were not QCBs. And on the other hand, so far as the subsequent loan notes are concerned, they're all QCBs.
Indeed, my lord. But that presupposes that the inclusion into the plural conversion of securities is a singular one, which excludes something else, which would otherwise fall within the meaning of the conversion of securities for that transaction. And we say, again, the language is just not there. So whilst it is the case that the 1997 amendments made it clear that a conversion of a single security is to be included in conversion of securities, it doesn't follow that it can't be in combination with other securities being converted at the same time, as a matter of ordinary language. Because it's an inclusive definition.
Sometimes Parliament uses the word includes to mean means and includes, and there is authority to that effect.
Indeed, my lady, but it's, I think, generally accepted that this particular provision is not meant to be exhaustive, and that has been considered by the court.
But it's also surely a convention of statutory drafting that you do not simply write out a list of illustrations of the proposition, but you either provide a genus group from which significance can be drawn, or an exclusive list.
So the genus is provided in sub 1, conversion of securities, and then sub 3A expands or at least clarifies that the following ones are definitely included in it.
If one might wonder why, if a mixed bag of securities can be treated as the conversion of a mixed bag into qualifying corporate bonds or bonds which are not qualifying corporate bonds can be treated as a conversion. Why bother to spell out 1A and 1B in the way that's done?
And the answer to that...
Why not just say a conversion of securities of a company into other securities of the same company?
Because the point that was being made by the inclusion of these provisions at the same time as the inclusion of the additional words in the opening paragraph of A whether affected by a transaction or occurring in consequence of the operation of terms of any security of any debenture. The point of the inclusion of these specific singulars was to make sure that an argument such as the type of schemes, such as those considered in Harding and Clink, will be dealt with, and they were identified here to make sure that there was no confusion in the effect of the amendments made in 1997, that it was dealing with a conversion of a singular security where you still had the same security, it had converted its status. And that's all that had happened. So we say that's why they've listed them out there. It's not to ensure that they get a separate treatment. It is to ensure that they are clearly included, even though you only have the one security, which is the same security after the conversion event, when it's changed its status from QCB to non-QCB.
Do you say that Clink has been reversed?
No.
No, I didn't think you did.
But the type of scheme that Clink was hoped was going to be successful, that's what this was aimed at, and the Harding type schemes. So if we go back to 116 sub 1, I identified a case clearly outside the language of sub 1, which was clearly intended to be outside that language, which is the case of a single QCB on the input side and a new QCB on the output side. And there are three further possibilities which fall outside the literal language of 1161B, where you have a QCB together with a non-QCB on the input side and a single QCB on the output side, which is our case. A further case is where you have a mixture QCB and non-QCB on the input side and both on the output side. And the final case is where you have a QCB on the input side and both a QCB and non-QCB on the output side. And one can understand why, in the cases where you only have a QCB on the input side, the draftsman would leave them out, because he's quite happy for section 132 to apply, as the case may be, or the 135 or 136, because if there is any stapled on gain, it will simply flow through with the replacement assets. So it's clear, we say, that 116 sub 1B is not meant to apply to all conversions involving QCBs. And we would say that if the Court of Appeal are right, not only does our transaction fall into two separate parts, but so also would the the transaction which falls within the second part of lim A, where you have QCB and non-QCB on the input side and a non-QCB on the output. Not that that would cause much harm, but it would simply mean that that part of 1161B was redundant, and I acknowledge that arguments of redundancy are not very strong, but it's another indicator that the draftsman here was doing what he intended to do, not something else. Now, if we think that the Court of Appeal are correct, then where you have QCB and non-QCB on the input side and you have them both on the output side, you've got two transactions. And if you have a disposal of any part of the output side, you are faced with a challenge to know which bits of the input side have been attributed by way of cost or held over uncrystallized gain. So subsection 10 of 116 operates by postulating a deemed disposal and then operates by saying, well, the gain that arises on that deemed disposal has to be held over to the ultimate disposal event when it crystallizes. But if you've split the input element into QCB and non-QCB, the QCB bit will fall within subsection 9 and give rise to an immediate charge if there are any gains stapled onto the QCB. And the non-QCB element will be converted into some of the new holding consisting of QCB and non-QCB, but there is nothing in the legislation which tells us how you ascertain how much of that new holding is attributable to the non-QCB element. So if it's all one transaction, then the provisions we saw at section 128 and 129 in particular about allocation of base costs by reference to market value, can apply if it's a single transaction. But the minute you start splitting it up, there's a difficulty because you don't know, you don't have 129 there as a solution anymore. It's a solution in respect to each part, but that doesn't tell you how the parts are to be allocated as between the two separate transactions. So we say there are mechanical difficulties with the approach which the Court of Appeal have adopted, both in our case, where if we hadn't disposed of the whole thing but only part of it, the question would arise, well, which bit of the two reorganized parts are we dealing with? Are we dealing with the pure QCB into QCB, or are we dealing with the non-QCB into QCB? How do you decide? Is it ratably? Where do you find that in the legislation? If it's a single transaction, the answer is found simply in the provisions of 127 through to 129. And if the Court of Appeal's decision stands, then it turns out that not only do we have two transactions, but the operative charging provision is different, because if we split what we did into a transaction involving QCB in and out, and a separate transaction involving non-QCB in, QCB out, the QCB in transaction doesn't fall within 116 at all, QCB to QCB. The non-QCB transaction does, and we get a stapled on gain there. Now, maybe at the practical level that doesn't make any difference. But if you have mixed outputs, then I submit it does. So, my Lord, we've said that there should be no taxation without clear words, and that, of course, is a well-established principle, subject to limitations, and if I can just remind you of those limitations. We find a clear statement of the principle in Ramsey, and your Lordship is probably very familiar with the passage. It's to be found in the Authorities, Volume 2, page MS 850, in the speech of Lord Wilberforce, where he says, a subject is only to be taxed upon clear words, not intent or upon equity of an act. Any taxing act of Parliament is to be construed in accordance with this principle. And then, of course, he goes on to say what are clear words is to be ascertained upon normal principles. These do not confine the courts to a literal interpretation. They may indeed should be considered the context and the scheme of the relevant act as a whole, and its purpose may indeed should be regarded. And when we accept the whole of that formulation, but we say, in these circumstances, the words and the scheme are not clear enough to force the treatment which the Court of Appeal says is the appropriate treatment, we say to shoehorn us into the tax charges in 11610. We say it goes too far. Not only is it construing the words in context, but it's reading in words, and we're not quite sure what they are, into 127 through to 130, so as to cause a single conversion to be treated as two. And it's worth noting that Lord Justice Floyd, I'll take you to the passage in a minute, accepted that in the context of a reorganisation, you could have more than one input. So the difference in treatment that is being said to be justified by a necessary adaptation rests on solely on the different tax status of the elements of the input, which we say is not at all clear from the combination of these provisions. Far from it being something that is clear in the context, we say it's simply not clear. Whilst we're at that passage in Ramsey, it's perhaps worth just reminding ourselves about the underpinning of the other limb of the approach summarised in Barclay's Mercantile, the realistic view of the transaction. We find at the under point 4 on page MS 850, Lord Wilberforce says, given that a document or transaction is genuine, the court cannot go behind it with some supposed underlying substance. This is a cardinal principle, but it must not be overstated or overextended. While obliging the court to accept documents or transactions found to be genuine as such, it does not compel the court to look at a document or a transaction in blinkers, isolated from any context in which it properly belongs. If it can be seen that a document or a transaction was intended to have effect as part of a nexus or series of transactions, or as an ingredient of a wider transaction intended as a whole, there is nothing in the doctrine to prevent it being so regarded. To do so is not to prefer form to substance or substance to form. It is the task of the court to ascertain the legal nature of any transaction to which it sought to attract a tax or a tax consequence, and if that emerges from a series intended to operate as such, then it's so viewed. My Lord, the point of reading that passage to you is to remind you that the realistic view of the transaction, which the ordinary principles require you to adopt, is not an approach of substance over form. It is directed at ascertaining the legal substance or the legal nature of what's happened. And that, my lords, I say, takes us back to where we started with the facts. We started with the fact that there was one agreement under which each of the two individuals gave up two things and got one back. And we say that, viewed on any ordinary analysis, was a single event, a single transaction, a single conversion. And that's what we say is the clear view. There are a number of authorities in the authorities bundle which deal with the circumstances in which the court may read in or cure a defect in the literal statutory provision in front of the court. And I've included in the supplementary bundle one further authority, which on this point I would like to take you to now. And it's the Inco Europe decision of the House of Lords in 2000. It's in the second tab within the supplementary materials bundle. The decision may well be familiar to you, Your Lordships, and so if I may, I'll take you straight to the passage which I want to draw to your attention, which starts at the top of page 592 at letter A. So
you have an electronic page number.
I beg your pardon, my Lord.
I can find it.
I don't for this.
It's
Yes.
7.
Thank you, my Lord. So Lord Nicholl says, I'm left in no doubt that for once the draftsman slipped up. The sole object of the provisions in question was to amend section 18.1g by substituting a new paragraph G that would serve the same purpose regarding the Act of 1996 as the original paragraph G had served regarding the Act of 1979. The language used was not apt to achieve this result, given that the intended object is so plain, that the intended object of paragraph 37.2 is so plain, the paragraph should be read in a manner which gives effect to the parliamentary attention. Thus, the new section 18.1g, substituted by paragraph 37.2, should be read as confined to decisions of the High Court under sections of Part 1, which make provision regarding an appeal from such decisions. In other words, for any decision of the High Court under that part is to be read as meaning from any decision of the High Court under a section in that part which provides for an appeal from such decision. So there we have the court reading in words where it says it's plain something's gone wrong and it knows what words it needs to read in. And then Lord Nichols discusses the principles. I freely acknowledge that this interpretation of section 18.1g involves reading words into the paragraph. It's long been established that the role of courts in construing legislation is not confined to resolving ambiguities in statutory language. The court must be able to correct obvious drafting errors. In suitable cases, in discharging its interpretive function, the court will add words, or omit words, or substitute words. Some notable instances are given in Professor Sir Rupert Cross's admirable opuscule Statutory Interpretation. He comments at page 103, in omitting or inserting words, the judge is not really engaged in a hypothetical reconstruction of the intentions of the drafter or the legislator, but is simply making as much sense as he can of the text of the statutory provision, read in its appropriate context and within the limits of the judicial role. This power is confined to plain cases of drafting mistakes. The courts are ever mindful that their constitutional role in this field is interpretive. They must abstain from any course which would have the appearance of judicial legislation. A statute is expressed in language approved and enacted by the legislature, so the courts exercise considerable caution before adding or omitting or substituting words. Before interpreting a statute in this way, the court must be abundantly sure of three matters. One, the intended purpose of the statute or provision in question. Two, that by inadvertence, the draftsman and Parliament failed to give effect to that purpose in the provision in question. And three, the substance of the provision Parliament would have made, although not necessarily the precise words Parliament would have used had the error in the bill been noticed. The third of these is of crucial importance, otherwise any attempt to determine the meaning of the enactment would cross the boundary between construction and legislation. Those are general principles, obviously, my Lord, and I cite them just to remind your Lordships and my Lady of the task in front of you in the context of what we say this case is all about. We say it's not clear what section 1161B would have said if the draftsman had identified that the literal meaning was other than what was intended. But what it is clear is that the elements which have been described by the Court of Appeal as anomalous, the use of the word include on both sides of Limay, are not because of the difference in treatment in subsections 9 and 10. They can cause a difference in treatment. And so we say the court is, in this case, up against the limitation not only as to what the words would be, the final limb of the final point made by Lord Nichols out of the three, but also it's not clear that this is pure inadvertence, that this is just something missed out because of the complicated way in which 1161B interacts with sub 9 and 10.
I don't know, is there any assistance to be gained from thinking about how this applies to shares? I just say that because the argument against you focuses specifically on the law relating to securities, and it relies quite heavily on what section 132 says about conversions of securities and what is said to be pointers in section 132 towards an assumption by Parliament that we're talking about unmixed inputs. But it might be said against that so far as shares are concerned, 1161 seems, 1B seems pretty clearly to be envisaging mixed inputs where shares are concerned.
And
now, does that take us anywhere?
well, it may not, my lord, because if there are not QCBs involved, then they're not within 116.
But 1161B is envisaging in terms
There may be other things in there.
A transaction where either original shares consist of or include a qualifying corporate bond. Or include, obviously the important word.
So that in the context of a transaction or event within, for example, 135, an exchange, which might involve QCB on one or both sides, the same problem would arise, or could arise, if you had shares and a QCB on the way in and only shares on the way out. Likewise, under 136 in the context of reorganisations. Now, those provisions do have the protection of the anti-avoidance rule in section 137.
But is it also possible that in the remainder of Part 4, which we have not seen in its entirety, there are other transactions to which 127 to 130 are actually applied, which allow for and provide for the splitting up of the elements of the original shares and the new holding, so that the word "or include" has a proper function in relation to those situations?
The only situations which fall under to be adapted or use the adapted versions of 127 through to 130 are the three further sets of provisions we've looked at.
But there are other provisions in Part 4 which do provide for allocation as between different classes of security, I think.
Not that would
but to which
have any relevance to this issue.
Well, they are transactions to which 127 and 130 are applied, and therefore 116.
No, the only sets of transactions to which 127 to 130 are applied are, beyond reorganisations that fall within them expressly, are the conversions, exchanges and reconstructions that we've talked about.
In the rest of Part 4, dealing with mergers, transparent entities and all the rest of it?
Those provisions don't directly add to the analysis, no.
You're rather overrunning your time now, I'm afraid, Mr. Sherry.
I'm conscious of that, my lord. And so if I may swiftly, if I can take you to the Court of Appeal decision, there are a series of observations on the Court of Appeal decision in our written case and also in our grounds, where we actually look at the paragraphs in the Court of Appeal decision one by one. I won't repeat those, but if I could take you to MS page 112.
Well, you'll have to do this very quickly because we need to allow adequate time for the response as well. But do take us to list just now.
My lord. Paragraph 66 on page 112. Even before one comes to section 116, therefore, it would be apparent that the two types of conversion which are specifically picked out in 132 may need to be treated separately, not aggregated. That approach, in my judgment, can be justified as a necessary adaptation. Well, you have my submissions on that. And if you go over the page, paragraphs 69 through to 71, you see where his lordship says that the drafting of 1161 is anomalous. Well, both sides accept that there are anomalies, for example, in subsections 2 and 3, as well as in 1161, so it is difficult, it's not. But what we say is that 1161 is only anomalous if you adopt the approach which the Court of Appeal adopted below. So, my Lord, if I can just very quickly...
Just trying to understand what's said in paragraph 69. Lord Justice Floyd says in the first sentence that he recognises that 1161b expressly countenances a transaction, it expressly allows for a fiscally mixed input.
Yeah.
But then he says that section 1161b is not saying that a conversion may include mixed inputs. So presumably he must be meaning a conversion of securities, is he?
I assume so.
Yeah.
And yet, so that... So it's only a conversion of securities, which he says will always be separated out if they are of mixed homogeneous tax status.
He means a conversion under section 132.
I assume so, my Lord, yes.
Because that's where section 1162 tells you to look for the relevant meaning of transaction in this context.
Indeed.
Yeah.
My Lord, I think you have all my submissions rather than repeat them.
Yes.
I would just emphasise that the 8 possibilities, of which only 4 are covered by 1161b, would not make it surprising if what we say we have here does not fall squarely within it, because there are others, some of which are definitely intended not to fall within it. My Lord, unless there's anything else that I can help you with before
I don't think so, Mr. Sherry. Thank you very much.
Thank you.
And do you follow Ms. Montes-Mazzano? No. Mr. Gibbon.
May it please you, there are 2 central interrelated questions on this appeal, my lady. First, what is a principled way of identifying whether there are one or more separate conversions to which section 132 of the Act should be applied? And second, on the correct application of the law, was there a single conversion or were there 2 conversions on the 7th of May 2003? They're not the only questions, but dealing with those questions will be uppermost in my submissions. In practice, it's not possible to draw a bright line between them, and I'll be illustrating my points by relation to the facts of the case. I put the issues in those simple terms, in particular because, as Lord Justice Floyd remarked in the Court of Appeal, and this is paragraph 75, MS 114, he didn't detect any real dispute from the appellants that if what happened as regards each taxpayer on the 7th of May was properly described for the purposes of section 132 as 2 conversions, and therefore 2 transactions, the result was anything other than the appeal should fail. Mm-hmm. Now, just to spell that out slightly, by reference to the facts, In relation to the revised 0301 loan notes, so the smaller set of loan notes, there was an associated frozen gain on those loan notes by virtue of the deeds of variation on the 9th of October 2002. And that was a conversion from non-QCB to QCB within section 132 A, Roman 1A, which meant that sections 127 to 131 prima facie applied. It was also a transaction for section 116, subsection 1. Therefore, section 116, subsection 5, disapplied 127 to 131. And by section 11610, it was treated as not being a disposal and the gain was frozen. And the parties agree that that's the correct analysis of what happened at the end of 2002. And that's recorded in the Court of Appeal judgment at paragraph 12, which is MS 98. Now, thereafter, this is on my approach that there are two conversions. Thereafter, what happens on the 7th of May 2003? Well, on that date, the revised 0301 loan notes were converted to SDLNs, and that was a conversion of QCB to QCB. That simply brought sections 127 to 130 in operation, the two fictions my learned friend mentioned. And when the SDLNs were disposed of for cash on the 30th of June 2003, that brought into charge the frozen gain. And it's also common ground that that is the case, as recorded again in paragraph 12 of the Court of Appeal's judgment. So the third element is quite short on that footing. It's the conversion of the 08-2000 loan notes to SDLNs, which was a non-QCB to a QCB, itself now leads to a frozen gain which falls into charge in June 2003. But going through that sequence there, if you noticed on the second step, it is agreed by my learned friend that in relation to the revised loan notes, that there was indeed a QCB to QCB conversion in May 2003, because that's what gets him to the disposal in June, being a disposal which brings the tax into charge. So he has, in parallel to his argument before you today, accepted that point in relation to one chunk. So for that purpose, at least, you can identify a single conversion of the revised B loan notes. So that's, if you like, the framework within which we say the submissions need to work. In terms of how I'm going to structure my submissions, there'll be three broad headings. First, the scheme and purpose of the legislation, which I hope shouldn't need too long from me. Second, I'll deal in sequence with some specific points on section 132, 127 and 116. And as you'll appreciate, we say that the correct starting point is 132, dare I say, for the reasons that the bench has been putting to my friend this morning. And then finally, as a freestanding heading, if you like, what is the relevance of the documentation entered into by the Hancocks on the 7th of May 2003 in assessing what's happened. So starting with the purpose of the legislation, we respectfully say that courts and tribunals have consistently had no difficulty in ascertaining the purpose of the relevant legislation. And that's not just in this matter, but also in previous cases concerning qualifying corporate bonds, which are in bundles. I'm not going to go through all the material. I do want to show you briefly the Billingham and Cooper case, with which no doubt many of you are familiar. That's at Authorities Bundle 1, tab 29, and that's MS 570. Now, the facts of this case perhaps needn't trouble you in too great detail. It concerned gains held offshore and provisions in the taxation legislation as to how you taxed benefits received onshore, and there were difficulties in relation to that. But the general statement which Lord Justice Walker made as to the approach to legislation, we say holds good just as much in this context. And you find that on MS 579. And he'd gone through various difficulties that both sides' interpretations of the legislation presented. And what he said at paragraph 35 was this: whatever the difficulties, the court has to do its best to make sense of the statute. And that means not only making grammatical sense of the text, but also finding a rational scheme in the legislation. That is not to say the court should start off with preconceptions about what it expects to find, or that it should shrink from saying so in the rare case where a tax statute has plainly missed fire. And then he goes on to include the quote from the Lord Chancellor, Lord Simon, in Noakes. If the choice is between two interpretations, the narrow of which would fail to achieve the manifest purpose of the legislation, we should avoid a construction which would reduce the legislation to futility and should rather accept the bolder construction based on the view that Parliament would legislate only for the purpose of bringing about an effective result. So we say that's a perfectly general proposition. We then would refer the court to the Jenks case. So if you put Authorities Bundle 1 away, if you've got that open, Jenks is found in Authorities Bundle 2, tab 36, which is MS 709. Now, it's worth going into the background on this case with just a little bit more detail. This was a case that concerned qualifying corporate bonds. And the background was that the QCB status, as my friend has mentioned, was introduced by the Finance Act 1984, at which stage one of the requirements in order to be a qualifying corporate bond was that the relevant company either had to have the bonds listed on the stock exchange market or dealt in on the USM, or it needed to have its shares so listed or dealt in. What happened in 1989 is that that provision was deleted, and a provision in the 1989 Finance Act deemed as regards disposals on or after 14th of March 1989, the change always to have effect. It was a retrospective provision. Now, the relevant facts were that in 1984, shares in a company which I'll call, in line with the head note P, were exchanged for loan notes in a company called M, and that was dealt with at the time under the equivalent of section 135. 135, it was no disposal and the same asset. In 1987, there was an exchange of those new loan notes for stock in Inc., and again, at the time, that was no disposal and the same asset. And then the relevant tax questions arose in relation to sale of stock in the early 1990s. Now, the taxpayers argued, and it's easiest to show Mr. McCall's argument to demonstrate this, and this is at 724. Going into slightly more detail than I might do sometimes, just to make sure that the context of the observations of the judge are clear. Letter G, Mr. McCall contends that the proper application of the legislation to the disposal of non-voting stock in 1991 to 92 is as follows. First, the disposal of the non-voting stock was a disposal.
So I'm not with you. Which page?
I'm sorry, it's page 724, and we're at letter G.
Yep.
So Mr. McCall contends, just towards the bottom of the page, the last paragraph, that the proper application of the legislation to the disposal of non-voting stock in 1991 to 92 is as follows. First, the disposal was a disposal. Secondly, it was a disposal on or after 14th March 1989, to which section 139 accordingly applied because of the first prospective part of the subsection. Thirdly, the provisions of section 64 of and schedule 13.2 the 1984 Act, and that's what introduced the ancestor of 116, should be treated as always having applied, because of the second retrospective part of the section. Fourth, as a result of Schedule 13 being assumed retrospectively to have applied, A, the 1984 exchange was not to be treated as a disposal of the original shares, because the provisions of paragraph 10 were retrospectively to be treated as having applied in 1984. B, the 1987 exchange was retrospectively to be treated as a disposal of the loan notes, because the provisions of para 9 were respectively to be treated as having applied. C, as the 1987 exchange was to be treated as a disposal of the loan notes and an acquisition of the non-voting stock, the non-voting stock is to be treated as having been acquired in 1987 at a price equal to the value of the loan notes at the time of the exchange. Fifthly, and accordingly, the chargeable gain in relation to each disposal is to be assessed by deducting from the net proceeds received on that disposal the cost of acquisition, which is the value of the loan notes at the time of the 1987 exchange. And what the consequence of that is simply summarised in the next sentence. The result of this analysis is that any capital gain which the taxpayer actually enjoyed on the shares, so that the original shares, which it's intended to tax, as I'll show you, will not be treated as a chargeable gain and will therefore not be chargeable to tax. The gap is relatively small because although the shares have been held for longer, that's the date to which share values are rebased since an act in 1988. So that's a bit of context, and it's in that context, I'm not going to ask you to go through them in detail now, but it's in that context that Mr. Justice Neuberger, as he then was, went through principles of construction. They're found at pages 726 through to 728. I particularly say you don't need to do them because to an extent they've been picked up by the Court of Appeal in this case in any event, but they do deal with certain other matters. And what I would also pick up on page 735 at the top, and this is on the question of whether the taxpayer's construction produced an absurdity. He said this is just after letter A. There is force in the point that if the result of section 1391 is retrospectively to wipe out what is effectively an accrued but deferred chargeable gain made on shares, that is a somewhat extraordinary and indeed absurd result of a provision whose purpose was to extend to a wider class of bonds, but plainly not to shares, the exemption from chargeable gains previously accorded to a smaller class of bonds.
There's actually quite a useful passage, I think, on page 730, between C and D, where he talks about the evident purpose of the relevant statutory provisions viewed as a whole, viz. The capital gains made on QCBs, because capital gains made on QCBs should be exempt from tax, whereas capital gains made on shares, and no doubt one could add securities, should be subject to tax.
My Lord, you're ahead of me. I was going to come back to that in the sense that that was the bit I'd quoted in our case. Yeah. But this is to give a slightly broader context to what was said in the...
Why are you showing us what he says about absurdity? Well, you're not suggesting that that's this case, are you?
Well, what I'm going to do, my Lord, with respect, is say that there are certainly parallels with what my friend is suggesting for these two reasons. First, the description to wipe out what is effectively an accrued but deferred chargeable gain made on shares is equally apt, we say, to describe the effect of my learned friend's argument in this case. The original Blue Becker's shares were shares which carried a gain. If the shares had been sold in 2000 for cash, that would have triggered an immediate...
I understand that. That's the whole point, that an apparent gain disappears in a puff of smoke. But it's really what principle are we applying here? It's not absurd that something falls out of tax because the revenue have failed to catch it.
Well, my Lord, no, but it's the context. The debate that was going on in the Jenks case was to a degree Is it absurdity or is it merely an anomaly? That's arguably a semantic
I think
distinction.
it's an important one. Here, the Court of Appeal says it's an anomaly, but they don't say it's absurd. And if, I think, for my part, I think it's rather difficult to justify this in terms of the authorities on absurdity.
My Lord, I'm not seeking to do that, but I am seeking to say that it's certainly at the more serious end of anomaly, to the extent there is a distinction between those things. But I do say that it's apt as a description of what happened, because it's worth reminding ourselves that it's not just a question of the original shares having been sold on an alternative imagining. If these bonds had been held to redemption, the same result applies, because these bonds carry with them the effectively accrued, and that's the phrase I'm looking at, really, the effectively accrued but deferred chargeable gain. So we say there is that parallel. And the second comment in relation to that passage is that we say the combined architecture of sections 132, 127 to 130, 116 is clearly intended to exempt gains on QCBs from being chargeable gains, and ensure that gains otherwise should be chargeable. Now, as I say, it's for that parallel rather than whether you label it absurdity or anomaly. But I do say the Jenks case carries resonances, if I can.
Yes, but we're not here talking about resonance, we're talking about principles of statutory construction. You know, it was arguably anomalous that the Duke of Westminster didn't have to pay tax on his employee. Well, it's certainly anomalous, but I don't think it was held to be an absurdity, and it's just that the revenue failed to catch that particular wheeze.
Well, my Lord, yes, and so, to be absolutely clear, I'm not suggesting absurdity, but anomaly. Certainly, if there are interplay of anomalies, as there are indeed here. So my friend is pointing out, as we agree, Section 116 has drafting infelicities, whichever way you look at it. And to some degree, when analysing the facts of this case, which is where we'll ultimately get to, you will be weighing the respective anomalies pointed out by the parties.
But the reason why it has these imperfections is probably because it applies to lots of different types of transactions within Part 4, because it's not just the 127 to 130 transaction, but anything which itself incorporates those sections. So rather than jump to the question, is there an anomaly or for which the court has to take an unusual interpretive pass, is not the question whether Parliament has in fact put in some mechanism or wording to try to prevent that. Isn't that the first logical step? And it's only if we're satisfied that there isn't such wording that we have to go on to consider some strained method.
My lady, with great respect, I entirely agree. And I was putting the general submissions on statutory construction now, really amplifying to a small degree what was in our case. But our central argument is actually there is a straightforward solution to this case, which involves no strain at all. And well, to get ahead of myself, that is simply to say there are, as a matter of law and fact, simply two conversions in 132. You go to 127 to 130, that takes you, in relation to each conversion, to 116. In relation to QCB, you'll say, no, 116 doesn't apply. To the extent it's non-QCB to QCB, it does apply and it operates coherently. And to the extent there may be other infelicities to be found on facts which we don't have before us in this forum, ultimately you're brought back to trying to resolve what is the dispute on this case. Are there two conversions? And as I say, getting ahead of myself, but in reality, yes, has Parliament put in place a mechanism so that at least on the facts before this House, there is a clear solution? We respectfully say that is the correct analysis.
It's useful to have that summary of where you're going. At some point, are you going to tell us how transactions involving what 1161B explicitly envisages, shares which include PCBs, how that's dealt with?
Well, Perhaps I should address that now. The difficulty with the shares analysis, and I'm thinking here about the reorganisation provisions in 127 to 130 primarily, which is what everything is fed through, is that you can only have shares on the input side. So you won't, in the 127 situation, be taken to 116 at all, if I can put it that way. And in relation to 135 and 136, these have emerged at a very late stage in the development of this case. With respect, we say it is very difficult indeed to deal with those theoretically without particular facts before us. But respectfully picking up my lady's analysis, what we're looking at, what we're trying to work out is how Section 132 takes us through this sequence, rather than, dare I say, speculating or hypothesising about how those provisions may work. And the Court of Appeal, similarly, when faced with my friend's points on this, took the view that those sections weren't before them to the extent it was relevant, and they didn't obviously make any final view of this. They pointed out that, of course, there are these specific anti-avoidance provisions which apply in relation to those cases. So in reality, it's very difficult to imagine situations where the sort of deliberate structuring that took place here wouldn't fall foul of Section 137. So that was the view they took, and we respectfully say, bearing in mind, 132 in itself has already, in my personal practice, led to 3 cases. There are others. That's even before one gets to other parts of this very complicated, dare I say at times challenging, set of interlocking provisions.
And I think there are other examples within Part 4 where the section actually says you split them into different classes of security.
I can take instructions in relation to that over the short
If it's
term,
any.
if it's of assistance. So seeking to amplify what's been said, there's one small point I wanted to make in relation to the Court of Appeal's decision when it went through what it described as relevant authorities. The quotation, this is back in the core volume at yes, it's at MS 109. I'm not spending any time already on Marshall and Carr, but if you look within the quote on the penultimate line,
Paragraph?
it's the paragraph starting at the top of the page, so slightly indented, MS 109.
I haven't got the MS numbers.
It's paragraph 46.
So that's in the core volume, internal numbering of the appendix 18, and you see there it says in the last 2 lines, the consequences and incidents naturally flowing from or accompany the deemed state of affairs. That should be inevitably, that's the word which you'll see quoted in the Jenks decision. We haven't got Marshall and Carr itself in the bundle. But as your lordships, your ladyship are aware that there's a great deal of authority on the question of the scope of deeming provisions.
Yes.
But that small correction, we didn't pick it up at the time the draft judgment was sent out, hence it appears in the report. Subject to those amplifications, we endorse the general principles expressed by the Court of Appeal. I needn't show you those again, but they are pages MS 106 to 109, but also show you 115 very briefly, where Lord Justice Lewison very pithily at paragraphs 84 to 85 summarised the purpose. First quoting the Jenks in the form that my lord's already mentioned, and secondly quoting my Lord Briggs as he was the Judge, on the second stage of the Harding appeal, the key to the successful operation of the frozen gain regime is that it displaces the ordinary rule that no chargeable gain or allowable loss occurs on the disposal of the QCB. Now, before I move on, just make this one last general submission. We do say it's a conspicuous feature of the appellant's arguments that they have made no general submissions on the purpose of the legislation. They simply, we would say, offer the negative proposition that there appears to be no policy reason, I think that was how it was expressed, for the effect they are seeking to press on this court. And we say that is to give up on the search for a rational scheme as required by Billingham. And we also say that the appellants to that extent haven't engaged with the central force of the revenues arguments. I was about to move to my second heading, which is to move through the legislation. If I'm conscious that...
Yes, well, I could make a start on that.
I'm happy to make a start. The starting point is this, and this is the phrase used by the Court of Appeal. Section 132 is the gateway provision. That's section 75, paragraph 75, which is MS 114. And similarly, Lord Justice Lewison at paragraph 81, which is MS 115, said this, paragraph 81, top of the page: although it appeared from the decision of the upper tribunal and the skeleton arguments before this court that the dividing line between the parties was whether the process of interpretation began with section 116 or section 132, it became clear during the hearing that it was common ground that the correct starting point was section 132. Now, I do say that's important to remember because to a degree my friend's submissions have started elsewhere, but certainly in the Court of Appeal we'd understood that it was accepted, as did the court, that the gateway is 132. Now, clearly, bearing in mind the scheme of the legislation, it would be wrong to consider section 132 as a standalone. It's part of an architecture, if you like, which has the clear purposes consistently identified in the case law. So this isn't, therefore, a case where the revenue is alleged to be trying to collect a tax which nobody could have foreseen. Quite the contrary, this is a case where there was effectively an accrued but deferred chargeable gain, which one could see the legislation was intended to tax. Now, in terms of 132, we've got a small series of points to make. First, there is no express requirement on the face of section 132 to aggregate different conversions which happen at the same time. And we do respectfully endorse what Lord Justice Floyd said at paragraph 64, which is MS 112. Said this.
Did you say 112?
112.
Thank you.
And it was in the context of a submission in relation to section 126, 127 by Mr. Sherry. A conversion, this is just after C, a conversion is not, as Mr. Sherry submits, an overall process, as a reorganisation plainly is. In a reorganisation, the overall process of reorganisation necessarily involves all the shares on the input side. There is just one reorganisation. By contrast, if one starts with two assets which meet the definition of securities in section 132, it does not follow at all that there is just one conversion. Each of the assets on the input side is converted to something else. It makes perfect sense to speak of each asset being involved in its own conversion rather than both assets being involved in an overall conversion. So we say that's a perfectly general remark that Lord Justice Floyd made, not reliant on fiscal status. Secondly, it is natural, we would submit, in the CGT context to focus attention in the first instance on what is disposed of. Here, there are two assets with separate characteristics. Thirdly, it goes further than that, because there are the pointers identified by Lord Justice Floyd at paragraph 65, and he says that although section 132 isn't exhaustive, he says it doesn't list any conversions with mixed inputs, particularly none with inputs with mixed fiscal status. And my learned friend has suggested in relation to that any of Roman 1, 2 and 3 could all amount to mixed conversions. But we say that's his inference. It's not found on the face of 132. And we say that's not consistent with general language, or more particularly, and this is my fourth point, the two specific examples that the legislature has chosen to put into section 132, namely section 132.3, subsection A, 1A and 1B, with an unmixed asset on each side. And we say, fifthly, on the facts of this case, it is without doubt that the two conversions can be treated as a matter of the ordinary use of language as two conversions. And it was that point which we were seeking to make in relation to the statement of facts and issues. To a degree, it could be characterized as a forensic point, but it has slightly more than that. Namely, I'm not trying to say I'm trying to trip my friend up that he's given away his argument, but I am trying to say as a matter of use of language, and that's not only found in the FTT, but that becomes more clear if you look at the statement of facts and issues itself, which is at 211, MS 211. So rather than being separated out as it was in the FTT decision from the issues here just follow straight on, and you'll see it's just that point in paragraph 12, subparagraph A. So it's the conversion of the August 2000 loan notes and the conversion of the March 2001 revised loan notes. So that simple point about language we were seeking to draw.
I wonder, Mr. Gibbon, if that's a convenient moment. Right, court will adjourn.